Hi everyone, my name is Josh and this is Mike, and for our individual presentation we got Regina versus Walle. Alright, so I'm just going to give you a little description, a little outline of what we're going to be talking about in this presentation. First of all, we're going to be talking about description of the case. Second of all, we're going to be talking about the main elements of the case. Third of all, we're going to talk about the majority decision. And fourth, we're going to be talking about the dissenting opinions.
Okay, for the description of the case and what happened, Adrian John Walle lived with Michael Stewart and Michael's mother. When asked, Miss Stewart called Walle a little socially awkward and described him as having developmental disabilities. Walle had stolen a .22 caliber rifle from his uncle in the previous weeks. He also shot the gun a few times with his roommate, Michael Stewart, outside. Walle was at a bar with Stewart and was asked to leave because they thought they saw something under Walle's jacket. Walle and Stewart left voluntarily. Walle and Stewart came back without something under his jacket and were harassing some of the women there, and they were asked to leave again. Walle then protested, saying he did nothing wrong, but they left anyway. Later, Walle was seen at a nearby Max Milk and got a gun and came back to the bar looking nervous. Walle was forcibly being removed from the bar by Mr. Ferguson and Mr. Shuckburgh, who is the owner of the bar. While this was happening, Walle dropped the gun that was under his jacket, insisted he didn't do anything wrong. Mr. Shuckburgh, the owner of the bar, told him to go home. Walle raised the gun and shot quickly, killing Mr. Shuckburgh. Walle went back to his residence saying, "I'd rather kill myself than spend years in jail." Walle was found by two cops and had a rifle in his hand. The police said he looked emotionless. Walle tossed the gun aside when told and was handcuffed and arrested.
Alright, so I'm going to take over the main elements of the trial evidence that was presented. First of all, the defense stated the facts that have been presented and established from the evidence that was found, that the crime at hand wasn't actually manslaughter and that he could not form the intent to actually kill at the time the trigger was pulled. They stated that his level of intoxication was too high and was not able to form an intent, therefore he cannot be charged with second-degree murder, and that he should therefore be charged with manslaughter. The defense counsel also brought up the point that he was claiming it was accidental discharge of the firearm at the time of the offense, but he had the gun held to Mr. Shuckburgh's stomach, and he was confining him in a little area where the intent was found that he did intended to not. He claimed that he intended to scare Mr. Shuckburgh and just point the weapon and create fear, but he held it right to his stomach at point blank and pulled the trigger. There's no accidental discharge on that, and he did have the intent to kill based on the evidence that was presented in trial.
So the actual decision. So when giving the decision, the judge said that the main contested issue was intent. The judge highlighted 7 points within the case. He highlighted that the appellant was familiar with and had previously used the gun. He knew the safety was off. He had the victim at gunpoint. He fired from a distance of 5 feet away. He knew that the gun was loaded. Moments earlier to the shooting, he said, "This isn't a BB gun," and he was also deemed not impaired. The judge also mentioned that a sane and sober person ends the reasonable and probable consequences of his act. The judge also found that the appellant deliberately pulled the trigger and murdered Jeff Shuckburgh.
Alright, for the dissenting opinions of this case, there really were no dissenting opinions for this case. All trial judges did agree that he did carry the intent at the time he did pull the trigger, and that there was no accidental discharge, and the level of intoxication was not high enough and could not be proved to be high enough by Mr. Shuckburgh, that he was not being able to form a mental intent at the time that the trigger was pulled and Mr. Shuckburgh was shot and killed. So in conclusion of this case of R.V. Walle, the Supreme Court of Canada found that the appellant's claim on his case of manslaughter to be dismissed due to lack of evidence to support the appellant's claim of intoxication and accidental discharge. Therefore, the judge did find him guilty of second-degree murder because at the time of the shooting, they did come to the conclusion that there was intent stated into the shooting, and that any sane or sober person would know that the consequences that would come out of pointing a gun at an individual's stomach and firing around to the stomach will cause death, or likely to cause death. And that Mr. Walle did claim during trial that he did know of the fact that if you do shoot a person, the consequences could come out of that, pointing a gun point blank at them, could lead to death and most likely will lead to fatal injuries. And therefore, for those reasons, he was deemed guilty of second-degree murder. And that concludes our case of R.V. Walle. Thank you.